Hello, everyone, and welcome to today's session on legal research and writing. I am Anusha Srivastava, instructional designer at EBC. This webinar is brought to you by EBC Learning, which is EBC's educational initiative. We provide on-demand legal education for everyone. The objective of EBC Learning is threefold. That is, to help remove hurdles to legal education, to empower you to make life-changing moves, and to, of course, help you learn and win. Our courses are available at ebclearning.com. Now, I'd like to introduce you all to our presenter for today, Mr. Shashikant Yadav. Shashikant is an oil and gas law specialist with 5 years of industry and teaching experience. He is currently associated with University of Dundee, Scotland as an academic researcher. He is also selected as a recognized scholar with the Center for Social Legal Studies, University of Oxford. Additionally, he has been working as a legal writing consultant with Walter Clover and as a consultant with NLU Delhi's Center for Environmental Law, Policy and Research. He has also been associated as a researcher with IIM Ahmedabad on Supreme Court analysis of India's energy sector, and his work has been published with Economic and Political Weekly, NUJS Law Review, The Hindu Business Line, and Journal of Energy and Natural Resources Law. He has been a part of the editorial board at National Green Tribunal Reporter and was felicitated with a plaque of honor by Bar Council of India for promoting clinical legal education. Now, the aim of this webinar is to clear the confusion as to how to approach legal research and make it impactful. As we all know, legal research and writing is an imperative skill to excel in any legal fields, be it litigation, corporate consultations, or academia and policy professionals. However, legal research and writing unfortunately gets the least training hours as compared to other substantive courses in a law school. Once out in practice of law, recent graduates face tremendous amount of pressure to take a 360-degree turn and understand the applicability of law to facts. Lawyers spend ample amount of time in interpreting, analyzing, systematically arranging facts in law and communicating their arguments. Each stage requires systematic research and writing exercises. Not only this, surveying, data analysis, empirical trends highlight the need for policy framework, and therefore think tanks, law firms, and other knowledge management firm looks for law professional with extensive publication and research record. Now, before I hand over the mic to our presenter, just a few preliminaries about the webinar. This webinar is available on demand, and a recorded version of this webinar will continue to be available on our YouTube channel at youtube.com/c/ebclearning. I repeat, youtube.com/c/ebclearning. We'd of course love to hear from you, so stick around for the question and answer session at the end of the presentation. If you have any questions, please send it through the chat tab at the bottom of your player, and we'll take them up once the presentation ends. And at last, we encourage you to share today's webinar with your social networks. You can use social sharing icons in the email invitation sent to you. So without any further ado, I'd like to kick off things by welcoming our speaker, Shashikant Yadav. Shashikant, over to you, please.
Thank you very much for the introduction, Anusha, for the generous introduction, I must say. And thank you very much, Abhinandan, for giving me this platform to interact with a lot of law students just over a tap. So I'm excited about today's session, and just to give an introduction that what we are intended to cover in today's session is when this opportunity of doing a webinar came to me, I was brainstorming that what kind of session should I take? Should it be domain specific, or should it be something which is talked about a lot in law school? And I found legal research and writing is one such topic which is very much talked about. However, the law professionals specifically in India are not skilled with respect to legal research and skill. So in this 1 hour session, what we are trying to cover is the basic premises of legal research, how it is usually done, what are the gaps in legal research in Indian academia, and how you individually can hone the skill. Because legal research is something which cannot be taught in the classroom as such, but a direction can be given. And I feel, as Anusha highlighted in her introduction, that legal research is given the least teaching hours as comparative to other practice and clinician subjects in law, which is putting our law professionals behind all across the world, because the kind of publications we do, the kind of output we make, the kind of policy analysis we do is all dependent on the legal research, and the kind of cases we also fight in the courtroom is also depending on the legal research. So before putting on my presentation, let me just give you one instance. So what happened in Portland, and it's a very interesting thing in Portland, and with Google and a lot of companies, what happened in past 5 years is that they lost a lot of $1 million suit just for missing one comma. And even if you just Google that $1 million comma, you'll get a lot of cases on that. And there is something called continuous comma or Oxford comma, which you put before and. So for example, if I say Tom and Hank and Sally are going for party, and if I say Tom, comma, Sally and Hank are going for party, that means Tom is both Sally and Hank. But if I say Tom, comma, Sally, comma, Hank are going for party, all three are different people. So these are the small things which lawmakers, lawyers often overlook. And it was realized in New Zealand also, there was a case, it was realized that there has to be a precision over how you draft your petition, how legal research happens, how policies are drafted, and such precision comes through practice and techniques. So I would be highlighting in my sessions such practice and techniques over the course of it. So let me just share a short presentation that I made, which also highlight the objectives. I hope, Anusha, the screen is visible now.
Yeah, it's visible.
Oh, great. So if you see the objective, I would be covering that how do you approach a piece of literature as legal material? So one thing which we all should understand right now is there's nothing called a law literature and a non-law literature. Everything in front of you is a potential legal material. A book by your favorite author is a legal material, or a piece of legislation is of course a legal material. So anything can be a legal material. A script of Bollywood movie is also a legal material, if you see. So how to approach a piece of literature as a legal material is what we will be dealing with. Then analyzing the overlapping legal issues, and one piece of literature may have 10,000 legal issues, but you need to prioritize legal issues according to your client's interest. So how to prioritize such legal issues, then understanding the multitudinous nature of legal research. So legal research has gone past the era where you just have to interpret few words according to Black Law Dictionary and get done with it. So that was a traditional method. But nowadays you have data analysis, you have policy analysis, trends, economics, everything coming into legal research, and we are trying to know how to integrate that method as well. And then probably I will touch upon the stepwise analysis of legal writing and research. So there is no specific stepwise shortcut that I could provide, but it's some basic framework that how you should do step-by-step legal research. The purpose of legal research, of course, and the last and the most important one, what is the importance of legal research and publishing? So even if you go to the courtrooms, to the law firms, to academia, to multinational corporation, legal research is a skill which is lacking among the law professional and which is most in demand. So that importance is what I would highlight in my presentation.
All right. Shashikan, there are few burning questions which I'm sure every legal law student, legal academician, or a professional faces. One of them is why legal research and writing needs a separate discipline of study. If you can highlight on that.
So if you see the presentation, it says key to becoming a legit researcher. So what is happening to begin with legal research in India, there's a lot of noise around. And there are a lot of publications coming up. There are a lot of call for papers coming up. However, the Indian universities and law schools in India are rarely among top 500 QS ranking, and their publication record is dipping down. In fact, Supreme Court of India, in a number of research based case laws, have said that the research in India is going down a lot. I would answer this question with, again, a case study. So I was on a project with National Law University Delhi where we were trying to know if CRPC is being read by the attendees, that 125 CRPC gives a quick maintenance in the case of domestic violence, or in case of divorce. If wife needs maintenance, 125 CRPC was executed, enacted to make sure that they get it quickly. And we did a survey across all the courts in Delhi NCR, that are they really getting the maintenance quickly? Now, how would you do it? You can't just start reading the petition and judgment and do it. You need to arrange the data set. You need to make pie charts. You need to make graph. You need to get the researchers on board, which knows how to use R and who knows how to do coding. So, and then we gave an output that 125 CRPC cases under 125 CRPC takes as much as time as under divorce cases. So the whole law is not doing for what it was made for. And so such precision and such objectivity is needed. And that is why it needs to be a separate discipline. It needs to be taught from an objective point of view. Gone are the days where legal research is just an opinion piece that you could write. Or no one would know, recognized publisher will publish such opinion pieces. So you need to cut the clutter, and you need to understand the publishing credibility. You need to be objective in your research. In doctrinal researches where you read and write, review literature, identify gaps, and do all that thing, you still need to be objective in your reasoning. And there are a lot of paid publishing in India where you can pay money to get published. Please cross-check whether these are indexed in Scopus and such journals. That is also very important, because these are the only journals which get cited, or under Indian authorities, are they probably Scopus indexed or not. And a lot of law students also think that legal research is just mooting. We get a problem and we research on that for around 1 month and present it and win a moot court and celebrate it. But sadly, that's not the case. In mooting, you get a fictitious problem, and on which you research and you deliberate and come up with a memorial. That memorial is, again, a very subjective argument that you put forward. That is not legal research. So even if you are doing a clinical paper on mooting, that's not enough, because you are dealing with the arguments, reasoning, and interpretation according to you. What about the objective analysis of it? That can also only come under a separate domain, which is legal research. And publication record, I guess everyone would agree, is one of the most important aspects on your CV. If you get published with one of the internationally recognized journal, nothing more is louder on your CV than that. So you definitely need to understand that legal research needs attention in India. Just another example, I'll quickly run through that. I was also dealing with Setu Sumandram. I was researching with Setu Sumandram case. If people remember, that's the case in which we were trying to know the bay which joins Sri Lanka and India. And that Setu Sumandram line which joins Sri Lanka and India, which is related to our mythology, Hindu mythology as well. In that, it was vanishing, and it was an environmental law case. And when I was assisting a lawyer in that case, the major issue was that how to prove that there is a depreciation of natural resources in there. So you need to go and do carbon dating of resources. Now, to do carbon dating as a lawyer, you need to deal with statistics and data. And I was, as a fresh graduate, I had no idea how to approach legal research through a scientific carbon dating perspectives. And that is why a lot of self-learning happened. And that is when I realized that that it's a field where law schools are completely lacking, or it's deemed to be understood that once you get a law degree, you are a legit researcher, which is completely wrong. To prove a point in the court of law, in the law firm, you need to have those tools ready with you, honed, skilled, sharpened, and edged therein. So of course, there are legal writing courses that you can opt for, but they can only give you direction on how to process about it, but skills have to be developed by you only. And over the period of time, you can make a domain specific field. If you research, you can make a name of yourself by deploying these tools for you. So definitely, Anusha, I think legal research needs a separate study. It should be at least a 4 to 5 credit subject in each of the law school, if we aim to make our law school one of the top 500 in QS ranking. And yeah, so I think key to becoming legit researcher is to cut the clutter and to make sure to deploy objectivity in your research. Anusha? Hello? So yeah, let me process. I was waiting for some questions. Let me just process with the rest of the part of my presentation in that case. So let me just start with a stepwise process. So as I told you that there is nothing cookie cutter here that I could provide you that how to do a research, but let me give you some example that how to process it. Now, for example, I was talking about Oxford comma, and I was talking about millions of dollars lawsuit which people have lost because of one comma. So if you see, there's a very interesting case in Portland, and there is a dairy product owner. So that person manufactures milk and milk products, cheese and your cottage cheese, etc., etc. And the person is supposed to pay to its employees money for transportation, distribution, packaging, etc., etc. Now, if you write transportation, distribution, and packaging and put comma only between transportation and distribution, that means distribution and packaging is one process. But if you put comma between distribution and packaging just before the end, that means distribution is a separate process and packaging is a separate process. Now, if you miss that comma, that means if you pay $100 to an employee, the employee is supposed to do both distribution and packaging. However, if you put comma, that means you have to pay $100 separately for packaging and separately for distribution. And that was precisely the lawsuit. And it was found that just because one comma, they were supposed to pay millions of dollars to their employer because they claimed that they were underpaid. Now, the point which I'm trying to make is that precision is key to research. The grammar is key to research. And one of the basic things that you need to do over the 5-year law course is to make sure that your literature, your reading, your writing, and your grammar is cutting edge. And that could only come through reading. You don't have to indulge into a practice where you just open book a night before. You need to be totally reading well-researched pieces over the course of your 5 years. And that includes the journals which are recognized, etc., etc. So that is one thing which you need to understand, that one of the key area to develop legal research skill is over the 5 year of your law course, you need to be reading at least something at every day, which is well researched and well drafted. And the second thing which you need to know, to be relevant as a legal researcher, you need to know what is the contemporariness of your issue. So for example, if I sit today and if I want to know that how law developed in India with respect to environment, and I would go back to Chipko movement. And when I talk about Chipko movement, which is as simple as hugging a tree by a tribal community, I would obviously understand the tribal rights of today as well. So you need to understand that how your historical research, how your legal research of past is going to serve the present community. So whenever you pick up a legal topic out of something, please make sure you understand the contemporariness of it. So for example, if we talk about famous movie Lagan, which is an Oscar nominated movie, and in that Lagan movie, they talk about taxation, right? And they talk about unfair taxation during that point in time. And if you link it with GST and other taxation in India today, such kind of unfair taxation practices in past, and you try to make it a point that such taxation have been said to be unfair in past and cannot come in contemporary scenario, you can make a valid point. So the first thing you need to understand is what is the contemporariness of your research? How is it relevant in today's scenario? And the world is right now fighting with COVID-19. If you see the legislation passed when there was Black Plague and other diseases back in 1913, um, and legislation passed during COVID-19, they are similar. For example, in Maharashtra, a recent legislation was that you need to stop fake news, and which and I think a reporter from a very reputed media house has also been under arrest therein. And if you go back to 1913, the similar provisions were passed by different jurisdictions, that one who shouts on the loudspeaker with something which cause nuisance to public should be held behind the bar. So we need to understand that whatever we research, whatever topic we pick up, we need to link it with the present issue. And then you need to know whether it's worthy of research or not. For example, um, over the past 3 years, whenever we are talking about picking up one research topic, everyone will talk about how efficient in environmental law, how efficient is National Green Tribunal. Now, if you just Google, and with Google, I mean Google Scholar. So as a researcher, when I say Google, that does not mean that you go to google.com, you go to Google Scholar. And then if you Google efficiency of National Green Tribunal, you will find at least 1,000 research papers. And they have more or less employed various kind of research methodologies there. Now, if you want to pick up the same topic again, and if you want to do research on the same topic again, you would want to understand how differently you're doing it. Or if everyone has done it, what value addition you're doing to that research. So number one, while picking up the topic, you need to know the contemporariness of the topic. You just can't research on something historical which has no relevance to present time. No one will be interested in reading or publishing that kind of research. And if you are linking the contemporariness, you need to know whether is it overtly researched, whether people have already done research on it. So for example, to do efficiency on National Green Tribunal, you're trying to analyze 5-year judgments which are passed by National Green Tribunal, and then you're trying to know whether those judgments were really implemented. So if there was a ban on real estate sector in Noida, was there really a ban? And of course, that will require field research as well. So when you do, and that kind of analysis is already done, and you're doing the same kind of methodology, no one will be interested in doing that because someone has already done it and published it and read it. So always do a background check when you pick up a topic for your research with respect to its relevancy. Another thing is that it gets under researched as well, some topic at some point in time. For example, um, Trump recently, the United States president, over the COVID-19 discussions, he very smartly also said that we are planning to mine the moon. Basically, he's saying that we are researchers and scientists and space astronauts will go to moon and will start mining the moon. And a lot of legal issues open. So people said that moon is a common heritage. It is owned by all the countries across the world. How can you alone go and mine the moon? To which Trump said that I never signed an international treaty or ratified the international treaty as such. Now, space law is a field of law which we understand, but mining the moon by a country under mineral law is a severely under-researched topic. And you would probably the first one writing a paper on that. Now, how do you approach such topic? Because it's under-researched and you don't know how to get the literature on that. So in such scenario, when a topic is under research, you are expected to link the research with previously researched topic. So for example, mining of moon, you will try and collaborate that topic with property rights, that who owns the property, the concept of sovereignty in international law, the concept of economic zones in international law, and then try and find a relevance to the present topic, that this is the trend which we are following, this is the new trend which US is trying to establish, and does it sound feasible under the current rule of law, scheme of law, is what you would try and do it. So there are two things. If a topic is overtly researched, a lot of research has happened, make sure your research methodology is new. You're doing something new about it. And if it is under research, I would advise you to stick to the basic and link it to the research which has happened in past to a different topic, if it's altogether a new topic which is coming up in. So 3 things to pick a topic. You should always link the contemporariness of the topic. You should always know that whether the topic is overtly researched or under researched. If the topic is overtly researched, make sure you clarify in your research that this is the new method that I'm adopting and this is the new kind of data analysis I'm adopting. And if it is under researched, link it with the present discipline in law. So that is how you identify an issue. Now, a lot of law students would ask that in our submissions, which we do in the law school, we hardly get time to do that kind of research, or we hardly get time to get in to even choose our own topic, because a lot of time professors do it by themselves. So if you're not lucky enough to have your own topic, and if a topic is given to you, make sure the methodology that you adopt, because I think none of the law professor tell you that this is the method that you adopt. So for example, if you are doing a law project on, I've taken enough example of environment, let me take it for criminal procedure. So if you're doing a research project on neuroscience, how neuroscience is applicable on law, is it an admissible evidence? And if you know, if you research on that aspect, you would know India is referring a lot of neuro research law with respect to New Zealand. New Zealand and India are both Commonwealth country, and India is trying to make a law very parallel to New Zealand. Simple literature review will give you that idea. So probably you will write a research paper doing a comparative analysis between India and New Zealand, because both the countries are trying to have similar kind of neuroscience law. So make sure that you put in you personalize the legal research for yourself, and then you proceed with it. And always try and negotiate with your professors that if I publish the paper in a credible research by the end of the semester, they should be awarding you full or the maximum marks. So that way you have other kind of lucrative benefits as well. So now, once you have identified and you're convinced with your topic, with these 3 things, contemporariness, overtly research, and under research, you do something called literature review. It's a cliche. Now, the word literature review itself is a cliche, because everyone say that that first thing which you need to do is to review the literature. But what people don't talk about is how to review it. I was shocked to know literature review is not just reading 10 papers. And literature review is much, much more than that. So the first step of literature review is curating. Now with curating, I mean that most of the scholars, not only in India, across the world, what they do, they go to the software, they put double quotes, and they write the topic or the keywords of their topic. And they get around 50 results of their research paper. And they start reading it, highlighting it, and then make their own opinion and start writing a paper. That is the biggest fallacy of literature review. You're not supposed to do it. So the first step of your literature review is curating. So let me go back to Trump's dream of mining the moon. Now, if Trump wants to mine the moon and you want to write a critical research paper on that, probably you will not write mining rights in moon as your Google Scholar keywords. What you should write is property rights of states in international law. And once you read the literature on property rights and concept of sovereignty, you have established the argument that what a nation can demand, and how they will demand a particular property right. Now, once you have established that, you would go to something called common heritage, which means that all stars, sun, moon, space, everything is common heritage owned by everyone. And if Trump says that he does not agree with common heritage, you would want to know that on what legal basis he's saying so. Don't forget that Trump has a battery of lawyers sitting behind him, and he can very well prove that. So if you're trying to criticize his decision, it cannot be mere your opinion. So you would want to search a second set of document which is on common heritage property. And then you would go to international law and try and identify the gap, and probably then present your paper by saying that these are the gaps in what Trump is claiming, and this is what he has to do if he's claiming something which is close to similar to mining the moon, and what kind of legal problem will come in future with respect to that. So in short, when you do literature review, please try and identify the sub themes of your topic. Don't just Google Scholar the topic name. So for example, if you take mining the moon, sit down with a piece of paper, and with that I mean physical piece of paper, which I personally prefer. Make a flow chart that these are the sub themes which are coming out of your topic, and you want to cover all these sub theme and interlink all these sub theme. By the end of your sub theming process, it should look like a web of flow chart, and this is how my scheme would come up with, right? So your literature review should start with sub-theming, then curating, then flagging that these are the issues that I'm flagging, and then you identify the gap. Never start writing a research paper without identifying the gap. So if Trump is trying to mine the moon, the gap is common heritage property. How is he going to bypass that international law? Does he has an authority to do so? So that will become your legal issue or gap therein. And then the third step would be identifying is drafting that statement. Now, I've already highlighted the importance of English in legal research, and I've already highlighted your grammar should be perfect. Uh, if you miss a comma, $1 million gone for the companies. It's as simple as that. So your one statement, which we call as issue statement or the draft statement, should be very precise. Lesser the word, better it is. So the example which we are dealing with, mining the moon, I would probably write whether common heritage property principle allows the United States of America to mine the moon under international law regime. That's it. So that would be a simple research statement which will come after your introduction in your research paper, which is your major issue. So if tomorrow the case ends up in international court or in arbitration or in United States as well, uh, if you have that precise statement, your paper can be one of the papers which they use or cite in their briefs while pleading in the court of law. So that statement allows people to know what issue you dealt in your research paper. And that should be very precise, worded very normally with simplest of the word possible, and then you will proceed with that. So I hope these three steps are clear. If you're these three steps are clear, then it will be easy for you to go to the methodology. Now, you must be wondering that this is only relevant to academia or certain kind of research, and you will be very wrong if you assume that. So, for example, if you're going um, to fight a case, and if you want to litigate, uh, again, identifying issue is one of the most important thing. So, for example, I help my father in dealing with criminal law cases as well at times. And while dealing with a criminal case, one of the first thing which you need to do is, under the piece of under IPC or CRPC, what exactly is the issue? What exactly is, whether it's an issue of fact, whether it's a matter of fact, matter of law, and how issues are coming up by clubbing both of them. Now, if the lawyer fails to make a right kind of issue, the whole case will flatter, and and you will be fighting the wrong case altogether against the state. Now, and similar in civil cases and in all other cases. So before coming up with the issue, before fighting that case, you need to know what is the main subject of your case, whether that subject is overtly researched or under researched. Then you will come, what are the sub themes of the case? You will go with the same process of reviewing the literature and then make the issue. So what we are talking about is very much valid when you make a draft plaint, when you write a research paper, when you're writing a consultation note for, if you're working for a law firm. This step is common all across the frame. You have to do it no matter you're practicing or an academician, or anything which is remotely related to law. And once you have identified the issue, once you have done the literature review, once you have done the contemporariness of the issue, then comes the important part, how you're going to perform it. See it as a drama, see it as a movie. So once you have done the scripting of it, there are movies which have excellent scripts, but when it comes to their acting, methodology, delivery, they fail. So your next part is that how you're going to do that research. So I will stick to the same example, which is mining the moon. I have 3-4 tools in front of me. Either I can just review the literature, and after reviewing the literature, I will go to the property rights, and then I will go to international law, and then I will say, look, international law gives property right to a sovereign state within its territory and little beyond the territory. And space law is something in which treaty has already been ratified, even though US is not a part of it. But a common knowledge or a common heritage principle is, those who have international law would understand, is just cogence, more or less. That means it's the basic law of international law, and Trump probably, or the US probably, can't go against it. So that's the stance you take. That is what you think as a law scholar, and courts might agree with you or might disagree with you. You don't know that. So you draft a research paper on those arguments, and these arguments are subjective. uh, there is no true or false into it. It's just your opinion, which might be close to rule of law, and it might be just far away from rule of law. You never know, right? Now, how do you make objective research out of it, which is something important? So what I would do instead is, I will probably do a comparative analysis. So for example, when I would uh, go several years back, when there was no concept of exclusive economic zone. So where a country's boundary end, under marine law, if for example, if country's boundary, if you take India's boundary, and if you go to the southern state where the boundary ends of the southern state, and you are allowed to mine the sea over nautical miles, over several nautical miles, you are allowed to mine the sea. Now, how that concept came in? You don't have a sovereign right, full sovereign right on the sea, but you're still allowed. There has to be an argument on it. Now, I will go back to the discussion and argument in the reports which were submitted during that point in time. And I would probably extend that argument to space as well. And I would say that's the future. And that is another round of argument that I can take, because that has happened in the past. So if you see, two research model, entirely two different outcomes. and court might adopt any one of that. Uh, Now you must be thinking, how do you fix that problem? Uh, to fix the problem, the more objective your research is, the more data driven your research is, the more factual your research is, the more acceptable it is. If you have a graph to show that how law changed over property right over the period of time from 1910 till 2020, and if you make that graph on credible data set, courts are bound to accept it because it's more of an objective research than a subjective research. So, so your analysis and your tool which you adopt is highly relevant. How you perform the whole drama, how you perform the whole theater of research is very important in that case. Um, let me take an example again of COVID-19. In United States, there is a case which has been filed against Republic of China saying that that coronavirus, novel coronavirus, is a conspiracy. Actually, a case has been filed in United States, and if you are a lawyer against that case, for example, if you are representing China, or the companies therein or the parties therein, and if you're trying to say, no, it's not a conspiracy, the first thing you will find is a research paper published in Nature, which is the most credible research journal in the world, which has proved that coronavirus is not bioengineered. And if it is not bioengineered, it means it is not manufactured and it's naturally jumped out. And a whole lot of probability of the petition of your opponent goes out of the window by just citing and developing argument around it. So it's an objective research. The graphs are given in journal therein, and you can use that objective research to make objective arguments therein. And however, the petition is just on conspiracy theory. There are subjective analysis to it, etc., consequential analysis to it. But that will not matter because you have presented something objective. So always look for objectivity in legal research, which is very tough to find therein. So there are three tools which you can see in presentation. These are brief tools. One is comparative. So I compare two pieces of legislation, two eras, 1910s and 2020, or I compare two different nations. For example, in neuroscience law, I told you New Zealand and India is getting compared, and then come up with an argument. Second is territorial, where you stick to the law of the land and then try and develop an argument. For example, in the starting of my presentation, I told you about 125 CRPC. Is 125 CRPC really successful? Now, for that kind of research, you don't have to compare it with any other country. You just have 5 court of laws. For example, you go to Saket court, you go to Gurgaon court, you go to Karkarduma court, and you try to know how long they took to how long it took the wife to get the compensation given in 125 CRPC. You draw a graph, and then you go to the court of law and probably say the legislative intent of 125 CRPC is still undone. It's still not implemented. So we need changes in 125 CRPC. Your argument will be very strong. So these are the territorial research where you stick to the territory. You don't go into comparative analysis, and your gut feeling and your common sense. And when you do legal research and literature review, you would know. And then there is interdisciplinary, which is part of every legal research now. Another major complaint which I have with a lot of Indian style of researching is it is opinion based, and it is very unidirectional. If I pick up a topic, we only just read the legislation, its interpretation, and what the stalwarts have said about it, and then start drafting it, and with referencing and footnoting. That is not research. You need to go interdisciplinary in your research, and the whole word interdisciplinary is also oxymoron because research is nothing but interdisciplinary. So if I'm doing neuroscience, I need to know the strands of RNA. If I'm trying to know the economic impact of coronavirus, I need to know that whether coronavirus can replicate or mutate. Because if I do a research paper on coronavirus and its economic impact, and in that research paper, if I've only analyzed the first wave of coronavirus, which came in 2019 and 20, without knowing that it can mutate and there is a second wave that can also come in 2022, my whole graph will go out of the window because I've totally ignored scientific analysis of it. So you need to understand, whenever you pick up a topic, you need to understand what is the interdisciplinary approach to it. So my advice while doing an interdisciplinary research is, whenever you pick up a topic, write actors. I always see research as a drama. So whenever you pick up a topic, write actors in your topic. So if the topic is about coronavirus, the actors is COVID, the disease, the actor is economy, and the actor is states or the country. So these are the three actors. And how these actors are affected by law, then I'll write the piece of legislation, Disaster Management Act in India. And while deciding the actors, I'll assign roles to them, that these are the roles given to them under the law, and then I will know what is the gap. So and each and every actor have multi-face. In your life you also have multi-faces. In front of your parents you're different, in front of your friends you're different, right? Similarly, your actors in research will have multi-face. uh, and coronavirus scientifically will be different, economically will be different, and legally will be different. Legally it's a disaster, right? Biologically it's a disease, and economically it's recession. So at each discipline it appears to be a different thing, so you need to analyze it differently. And so once you identify the topic, you identify the research, make sure you identify actors of your research, assign roles to them according to your research, and then come up with the solution therein. So with this presentation I tried to give you uh, a schematic presentation on research, but to be very honest, you can't master it through a 1 hour seminar, or probably you need a lot of practice to master it. And I can just give you direction that how to go about it. So that is the stepwise process, usually in a basic standard research which we do um, at this point in time. Um,
Hello, am I audible?
yeah, yeah, you're
Yeah,
audible now. Yeah.
yeah. So I'm saying that I'm sure now we all have understood that how to choose a topic and how to go about the systematic approach of legal research and writing. The next question that arises is, what are the achievement indicators in legal research and writing?
So that is a very wise question. What are the achievement indicator? Now that means you've done your research. You're convinced that Trump can't mine the moon, or you're convinced that there is no second wave of coronavirus, so you can do an economic research now. Now, how would you know that your research is acceptable? How would you prove that in court of law? Now, first of all, whenever you start a research, please start it with the aim. Don't start it just to get the marks, or don't start it just to get publications on your CV if you are a professional, to just show to your recruiter, because they're smart enough to know that you're published in 10,000 places where you can just pay and get it done. So your performance indicator in research is what is the impact of your research. If you come up with a new finding, how impactful it is. So one of the most credible and most renowned indicator is whether someone has cited it or not. Whether Supreme Court actually, while dealing with 125 CRPC, referred your research while giving the judgment. So let me give you an example. It's not a very bright example to give, but that actually happened in India. There is a very renowned yet controversial judge who decided about domestic violence act, protection against domestic violence act. And while referring to the definition of domestic, he referred Wikipedia. Now, you know, that's a crime. That's a sin in research. You can't just, Wikipedia is the most basic thing which you're not allowed to do because it's an editable research. And that happened in High Court of Madras, where Wikipedia was actually cited to know the definition of domestic. That was a case in which live-in relationship were considered under the definition of domestic. The judgment was path-breaking. The judgment was something which was consequential, which changed the whole course of domestic law in India. However, the referencing was very weak, and hence the main question was that, and the referencing is not only in obiter but it's in the ratio of the case. So obiter is just the observation and ratio is the main crux law, which is presidential in nature, which the rest of the High Court could also apply. Now, how to fix that problem? Immediately, Supreme Court said that that doesn't mean Wikipedia becomes the law of the land. And although the definition was from the Wikipedia, but the cross-citing was from a research paper actually written in a Commonwealth country. So they came up with that kind of argument. So one of the clear indication is who is referring your research or what kind of audience you cater to. So if you're probably writing a research for just another blog in India, no one is going to read it. It will write a good thing in your CV, a good line in your CV, but your recruiters will be smart enough to know that you just published it by paying money or somehow. So you should always aim to write 1 or 2 research papers in a year. You should know which journal you are targeting. And if it's not about journal research, if it is about a case law, or if you are helping your senior in writing petition, or a law firm while doing an internship, you're presenting a policy paper, who is your audience? And whether your audience is receptive to this kind of research. Just another example, when I was doing an internship, uh, being a law student in an environmental law firm, and that was in Chennai, I need to do how important public participation is there in environmental law. I could have read a lot of books and write a lot of opinion on that. But when I chose 5 public participation meeting happening in Chennai, where the language is alien to me, and luckily I had a translator, and then I analyzed whether those 5 meeting as a sample size, uh, one by one has done all the legal process or not, whether the people legally who were supposed to be present there were there or not, whether minutes of the meeting were given to the villagers in the colloquial language or not. All these are written in law. So and obviously when I do that kind of research, the lawyer in the court will be more interested in and will be more receptive rather than my own subjective research. So your key indicator is how receptive your audience is to your research, be it the judge, be it your boss sitting in the law firm, be it your clients, or be it the journal which you're reading at. So that is one thing which you need to take care of. Never write a research piece just to write it on your CV. It's a wrong path you will be taking up into. Always write research or research paper to be impactful, to serve the audience. That is one of the key indicator, and you will always know that this is my key indicator. And students, don't think that you can't write such research paper. Remember, we don't have IT Act 66A because of a petition by a student, and we have LGBTQ plus rights in India because of students only. And there are a lot of petitions which are through student, where they have filed excellent petitions. If you read these petitions, they are excellent because the gaps are identified and they spoke with data. So you need to know what your audience is and you need to cater to them. And that is one of the major indicator. The second indicator is cross-referencing, as I told you. So if your research is cross-referenced. And the third and the major point is, how would you identify it? Please start visiting the Lok Sabha and Rajya Sabha website, where they have all the prospective legislation, what we call as bill, published. All the bills are nothing else but policy which are going to be made into law very soon. And if you write research papers on those bills, and don't hesitate in contacting MPs and MLAs with your research paper if you're confident about it, just email it to them, and just reach out to them that this is the bill which is coming in your constituency or in your subject matter, and I've written an objective paper on it. I've done a data analysis, and just reach out to them. Be shameless about that for sure. And these are the indicators and policy impact which you can come up with again. So for example, Shashi Tharoor in Kerala was doing a lot about climate migration. And I remember I was co-authoring a paper and we actually reached out, and and that research was referred in climate migration. And so you need to connect as a researcher. If your audience is not taking you seriously, then you need to build up objective data sets and analysis, and then that could be a very good indicator for you as well.
All right. Shashi, another question which arises from this is, what are the career opportunities? What are the career perspectives in specific research and writing field?
Okay, so again, a very interesting question. So it depends how you take legal research. As I told you, legal research is indispensable part of anything related to law which you're trying to do. So let me just briefly unlayer the career options in law, and then I'll come to legal research. So either you will litigate in a court of law, and in the High Court or in the Supreme Court. And if you hear people arguing, they're very precise senior lawyers, and they're very well known for their research. So drafting a petition is very close to drafting a research paper. When you draft a petition, you identify issue, you identify facts. Facts is nothing but your reviewed literature from a point of view. You identify issue, and then you pray something. Pray is nothing but your conclusion, that what you think about it. And in between prayer and issue, there is something called your method, that how did you reach to the prayer. So if you say that right to clean environment is under Article 21, or freedom of press does not mean misinformation or fake news, how will you come up with that argument? What is the method to it? So I told you comparative method, or territorial method, or you do data analysis. All of those methodologies is the gap. So if you are well versed with legal research during your 5-year course, you can draft a petition in litigation. If you are absorbed by being a corporate lawyer, and you're trying to tell um, your prospective client about SEBI rules, you need to tell them that why SEBI came up with new rule. If you're trying to make your client understand about GST, being a corporate lawyer, you need to tell them that why GST came, and what is the methodology government is adopting, and what will be its impact. So big firm like KPMG and Ernst and Young and all of them, what they do predictions. They are white collared astrologers, as we say them. They predict the market, right? And they have methodology to predict the market, and they need lawyers to do so. And lawyers without knowing these methods or research skills will not be able to do it. Similar with your tier 1 law firms. When you advise client about something, when you do their due diligence, you need these methods at hand. So whenever you're fresh out of law school, there are two things which you lack: procedural knowledge of law, which we can understand, you can bridge the gap through internship, but you will not be very akin to it. And second is legal research method. I think people talk about practical knowledge a lot, but rarely people talk about legal research as a professional uh, approach towards it. So definitely that is the second thing. Even if you now, the third thing is academia and core legal research. Sadly, 5 years or 10 years back, academia was taken as an alienated route of just lecturing. But now academia and policy making are very much integrated. For example, I'm working on oil and gas law, and India is coming up with that how to extract unconventional oil and gas law, and they want to make a law on it. And to make a law on it, now they are getting in touch with experts and scholars for making law on that. So there are career opportunity to being an independent consultant once you have made a name on that topic. Academia, research, if you publish credible research paper, definitely government needs all across the world such support. So I would say you pick up any field of law in which you want to venture into in your career. Legal research and methodology is imperative, indispensable. And if you know these tools, if you've been skilled through for 5 years in these tools, there's nothing like that. Another point which I want to highlight: there are a lot of legal research and methodology books out there, but rarely in India we have books which is from an interdisciplinary point of view. For example, it's National Law University Delhi, which did empirical legal research. I think they did a seminar or something like that from that, in which they said how to collect data and how to convert them into legal research. I gave you example of 125 CRPC, a project in which I was a part, where we collected data of 5 courts. And through those data, we did an analysis saying that you giving maintenance under 125 CRPC is not helping women, not helping a wife, deserted wives, because um, it taking the same time, the whole process. So legislative intent is defeated. So that's an objective analysis which you do. Now, actually, if you go to, if you do, go to the latest Law Commission report, they're trying to amend the whole process now. And that report was picked up by a Ministry of Women in India. And so there are a lot of career opportunity if you are a good researcher, from LPOs to the best of law firms to the best of lawyers. Your legal research will definitely come in handy. And don't forget, once you have good legal research, you have good writing and reading skills as well. And law is nothing but communication. So that is another important aspect.
Absolutely correct. So, any advice to the first year law students or the students who are about to study law? How can they integrate legal research and writing with other legal subjects?
So to begin with, if they can see my presentation, the art of legal writing slide, I'll just cover these points and then conclude by uh, some advice that I may be able to give. First thing is that I have seen a lot of people try to be verbose with what they write. Now, these, I'm just giving you some drawing table tips. I'm not giving you some expert tips right now, because technicality, I think we dealt with in my previous slide. So make sure you do not, when you have simpler words with you, do not just for the sake of it, deploy complicated words. Um, uh, and your research becomes non-readable and very pretentious when you do so. So try and get simplest of words. So for example, there are research papers which are just been written by using 200 words. 200 word in different permutation and combination, they formed sentences and paragraphs to make it very easy. So if you go to Nature, or if you go to the best of the research journals, they always used very basic words. And so lesser the word, better the meaning, is the key, and less verbose. And then you need to do reading before writing. There are a lot of people who form opinion without reading. And whenever, another very important advice which I have felt, because from past 7-8 years I've been interning, or I've been working, or I've been researching in environmental matters. So I tend to take an activist chair at times. I was like, this project should not pass, this should not happen, it's detrimental to the environment. But I cannot write an academic research paper with that attitude. My mentors would ask me to step back and see that piece of literature objectively, and then analyze that whether that what I'm writing is writing as an activist or as a lawyer. So even if you have an opinion about something, put that opinion at the back, read something contradictory to that opinion, read something which is totally against your opinion but makes sense. That will help you to balance out. And always read something which contradicts you, find gap in that, and then take those gap and write about it. Because then you're actually then you're actually countering what already has been written against you. So please read before you're writing. Read something which is aligning to your research, read something which is not aligned to your research, and try to counter what is not aligned to your research in your writing. So at least you should be doing 10 days of reading before start writing a research paper. You acquire the whole vocabulary or lexicon of that topic. Understanding anatomy of a sentence is also very important. Uh, People write huge sentences. People write huge conjunctions. Again, simpler the sentence, shorter the sentence, better it is. Readability is the core. Nowadays, no one have time to unlayer your language. Now is the time of quick digest of language. So the simpler it is, better it is. So you need to understand the anatomy. If you're doing a conjunction of two sentences, you also should know who is the subject and verb in your sentence. You can't be playing around with them a lot. So anatomy of a sentence is very important when you write. So always when you write, don't be very cautious about it. Just write how you write. And while editing it, spend a lot of time in editing your thing. And while editing it, just know the anatomy of your sentence, that how you form the sentence, whether it is right or not. And there are a lot of tools available online to check that. And of course, seek the help of expert if you're co-authoring with someone. Then there is something called blue paper and white paper method. So blue paper is in the starting of my presentation today, I told you that that come up with the sub themes, and your sub themes should act like a flow chart, and by the end of it, it should look like a web. So that is exactly blueprinting, where you do not say that I will do introduction, I will do research, I would do abstract, introduction, conclusion, like that, where you don't come up with subtopics, but come up with sub themes. That is blueprinting. You made a blueprint. Like when you start a building, you made a blueprint that here will be the bedroom, here will be this thing, that thing. So you would know that you define the territory of your research paper, or your research is blueprint. Always make blueprint. And in white paper, you do not define the boundary, but you define the sub themes, subtopics of your paper. Introduction. Now, introduction can talk about moon, sun, water, anything. You have not made the blueprint. So white paper are usually not recommended. Go to blue paper method or blueprinting method, where you define the territory of your research. Then there is something called black letter method. That means mere interpretation. A lot of you will read about statutory interpretation. Again, a very important subject. How do you interpret word? Um, a comma can cost millions, right? And the word, for example, domestic word, no one would have thought 20 years back domestic word will also include live-in relationship. And now domestic word also include same-sex marriages, right? No one would have thought. So the interpretation has changed over the period of time. Now, if you read a paper of 1970s and you're trying to quote it in your research paper today, for defining domestic, your paper is outdated already, right? So black letter method means going through the interpretational research. And there are interpretation tool which you will read. Due to short of time, it's altogether a different course. There are different kind of statutory tools. Make sure in your law school, read it very, very thoroughly, your interpretation of statute. It will be used a lot. For example, in taxation law, you do strict interpretation. You don't go behind the meaning of the word in criminal and taxation law. Wherein in constitution law, you usually go behind the word and try and understand it. So these are black letter methods in which you interpretation and you deploy those tools. Then there is analytical method in which you come up with a data set and you try and find whether these data are relevant or not, and then you apply those data. So another advice to all the law student, there are a lot of law courses. So there are a lot of normal courses on data analysis, and data analysis is future of law. And there is not even a single course in India which is statistics for lawyers. For example, I think Oxford runs that course, and University of Dundee in Scotland also runs that course, where how statistics is important for lawyers, and they do a full 3-credit course on that. So if I'm trying to say that COVID-19 will have economic effect and we should change law in future, in that situation, I should have data in front of me and analyzed and linked it to the law. But you need to know how to read data. You need to know how to make data. You need to know R is a software which comes up with data. All these techniques you should know. And I don't think any of the law school does that in India. You can come up with a demand and tell your law schools to do so, because they're very innovative and receptive to it, which is a very good thing about our law schools. So, and if they don't, there are free courses available for that. Go for data analysis courses, and that will really help you to make objective research in the courtroom as well. I've already discussed comparative and deductive method. And the last one is prognosis, which is opposite of diagnosis. So diagnosis means you have symptoms and you're looking for disease, that what disease you have. Prognosis means you know the disease, but you're trying to know the symptoms. So you know that recession is there, but you don't know why it came. So that is a prognosis disease. That is a prognosis research. So you know that there is an issue in society, but you don't know why that issue came. Now, until and unless you don't know why that issue came, you can't make law on that, right? So you need to know. For example, the classic example for this is rape. So you know there is an issue of rape in India, and you can have strictest of punishment, you hang till that punishment, but they're still occurring in India. So it's a prognostic research to know that what are the cause for it. Is it the patriarchal mindset, or is it the toxic masculinity, and how law can deal with that? Is a prognosis method, which Law Commission of India is also doing. So that's a classic example of prognosis method of research. And last but not the least, in which a lot of law school pay emphasis is footnoting and referencing. And you will definitely have workshops in your law school in that. However, do not forget, in social science and in other science, your blue book method and all these methods are not relevant. I'm not saying not learn them. Of course, learn them. Your blue book method of citation and your Oscular method of citation. You should be knowing that, but don't put too much of pressure on that. Nowadays, all the reputed journal in Scopus Index are coming up with something called uniform citation. You can have your own method of citation until and unless it is uniform, until and unless each and every footnote refers same thing at the same time in a same methodology. So it's fine if you doing a credible research, but that kind of uniformity only comes when you know what is blue book citation, what is this, what is that. A lot of law students get very pressurized about footnoting and referencing. I would advise you not to get pressurized about it. Take it in the last. Of course, keep on doing footnoting when you write it, but you don't have to be perfect about it. When you start writing a research paper, you can't just go back and forth and keep writing footnote. You break the flow, you break your research. Just keep referencing it side by side, and later you can fix it. It's not a big deal. There are editors in credible journals who can also help you out in that. The great deal is your methodology. And what right you can do from first year itself. Um, Please focus on objective research. Please focus on data analysis. Reach out to the right audience of your research, and don't just write to publish in XYZ journal. Always make a list of journal which are Scopus indexed or which are highly credible, which is UGC care list, etc., etc., and thrive for that. One great research paper is better than 10 bad ones. In fact, if you write 10 bad ones in all your CV, they will think that you're just in the opinionated writers and will not take you seriously. So yeah, so I think, and go for a course on legal writing and research if your law school does not offer one. That will immensely help you.
All right, thank you so much, Shashikant. Now, there are so many questions we have got from the participants. Let's quickly take up some of them.
Sure.
Uh, One question that has repeatedly come up is what is the importance of legal research for masters and doctorate?
Okay. Again, with respect to masters and doctorate, there is a presumption that you do it only to teach, which is again wrong. If you take a PhD degree, and if you're planning to do a PhD degree, your finding of PhD should lead to some kind of amendment, policy paper, policy change, or policy matter as such. So, so in your master's degree, for example, if you want to go outside and do your master's, they always ask you what you have a research piece that you have already written. And if you have written a research piece which is already published in Scopus indexed in your bachelor's, even if you're a co-author, you're done with, you are about to be picked for the scholarship for sure. So they always see whether you have done that or not with respect to masters. And doctorate is again all about research, but you need to make sure that you're not getting masters and doctorate just to teach and deliver and just to qualify to teach. You should always seek that what kind of issue I'm solving in the society. I know I'm sounding very idealistic with this, but as cliche as it gets, it's the truth. It's the truth. So you need to pick up a topic in your masters, knowing that what is going and what are the gaps in the society, and then only go to do that. Don't just do a master's to get a degree, which would be a wrong turn for sure. And don't just get a master's, a PhD just to have doctorate against your name. You should be having a calling. And mind you, doctorate is 4 to 5 years of commitment. And with a topic which you don't like, or you're just faking that you like, you can't survive for 4 or 5 years with that topic in a good institute. So that ways you need to know what you're trying to do with your masters, and don't just rush into masters immediately after your BA LLB. Do it when you're prepared for it.
All right. I got one very interesting question. So it is that how to deal with any problem, how to research on any problem where the law is silent about it.
Okay, so uh, do not forget that law is a sub branch of social science. We tend to forget that, and I would also go to an extent that we get snobbish about it. Law came from polity, which is politics, and social science. There are so many questions which are unanswered in law, and law is silent about it. But those questions and methodologies are already answered in some branch of social science for sure, right? So you write a social science paper in that case, and your conclusion is that society has this gap, and therefore there should be a law. And if you find something on which law is silent, it's a perfect example that you can do a PhD and master's on that. For example, my research is unconventional oil and gas. That means there's a new way to extract oil which came into the world, which is fracking, if few of you have heard about it. So my research is on how to make fracking environmentally sustainable. Law is completely silent about it, not only in India, across the world. Few countries have banned it, few countries like US have taken it to a different heights. But you need to know, and to understand fracking, I read geology. I actually did a 3 credit subject on geology, that how rocks are formed, because I need to know what is the structure of the rock to understand what is its impact on environment to suggest laws, So law was completely silent on it. So I had to read geography. I have to read about the society's perception about it, that is sociology, a part of it. And then only I came up with a conclusion. So I'm sorry to say, as a lawyer, you're not only expected to know law. As a lawyer, you are a very social human being. You should be reading all across the branches, and no branch is alien to you. Even computer science to any kind of even home science to any kind of science is very much relevant to you, depending on the topic you pick up. So please go to social sciences. The methodology that I told you of literature review and comparative analysis and all that is very relevant to social sciences as well. And then your conclusion should be that there is a gap and we need law. And probably you can write another paper that what law would resolve such issues by doing a comparative analysis. As I told you with neuroscience, we had no law, but we're looking up to New Zealand for that by doing a comparative analysis. And of course, the whole concept of neuroscience also came from social science and biology, where they were trying to prove criminality on the basis of that.
All right. Now, one question is on plagiarism. So the attendee has asked that can they refer an exact sentence by giving a reference?
You have to put that in double quotes, because plagiarism is checked through multiple softwares, and usually the credible research journals, if you put something in double quotation, I'm not talking about single quotation, I'm not talking about subparagraphing, I'm talking about double quotation. It is deemed that you have taken it as in verbatim, word to word, you have copied it. You can copy that, but you have to quote it, and then you have to cite it properly. That's not plagiarism. But your whole paper cannot be in double quotes, as you know. You can, and you can only use double quotes where it is relevant. Now your next question would be, how would I know that it is relevant or not? If someone has written something important which forms the crux of your argument or your theme, and you would know that when you are into research, then only take it. Do not take a piece of paragraph just because you want to increase words or you meet the word limit of that journal. And even if you do at times, put it in double quote, properly cite it. Softwares are really smart. There are anti-plagiarism software or also running there and around. that will not help for sure, because credible research journals are very smart that ways. So put it in double quotes, it never comes in.
All right. Maybe we'll take 2-3 questions more. There are so many of them. We can't take up all of them as we are very
And
short
also
of time.
another thing that I want to add about plagiarism is, in India they are okay with 20%, but outside anything above 5% is a crime. Plagiarism, I hope you know, is a criminal offense under Copyright Act, right? Academics from DU were behind the bar because of that. So you need to make sure you have to be, and if your legal research is not territorial, again, it's not only about India. Um, when you go outside, you will realize people really look up to what is happening in India. So people really read your paper if it has been published in some credible part. So make sure your plagiarism count, even if they allow 20%, should be below 5. Your institution will have subscription to it. And anything which is in verbatim, put it in quotes. Anything in which you change the language. For example, if a sentence can be written in 10 times, meaning can be 10 different ways, meaning would be same. If the meaning is same and you have just redrafted it, then you don't put double quotes, but you refer it, but you give the citation of that thing, right? So, yeah.
All right. So one question is, what is the thin line difference between article, blogs, essays, and research paper? How
Oh,
can one
very good.
differentiate between all of these?
So let me put it hierarchically. As a law student, if and as a law professional, if you want to be taken seriously about it, you should first establish your credibility. And your credibility will only be established by not writing opinion pieces, but by writing research papers. Do not just make a blog and start writing your opinions and then complain that I'm writing so well and no one is reading or recognizing it. And even if people will read and recognize due to PR, you will not be able to make a career out of it until and unless you have a lineage of it. For example, let me give you an example of Professor Bakshi, which you all have heard and read about. And I happened to have a meeting with him at his home. And the first thing he told me that he has never written a blog per se or an essay per se, because he was never confident that whether his opinion is right or wrong. In the sense, is it legally or morally right to give that opinion out or not? So he has only written what you call research papers, and probably in newspaper later on he wrote op-eds about it. So my advice would be, find your niche first of all, that whether you're interested in criminal law, you're very interested in neuroscience, or you're very interested in any of the topic, mining the moon, or it can be any XYZ under the sun, and write credible research papers on that. Collaborate with the best of researchers around the world. And another thing, we are very shy in writing emails to professors outside university. They're very approachable. They're more approachable than your university professors, let me tell you. So if you write a well-researched, nice email to them, they will respond. And you might end up assisting him in a research paper. Do that. Get the best of the people in your field, research about that. Write an email to them, offer basic research help to them. Slowly build your research papers, write your research paper, and then end up writing your blogs or opinion. Your route should be, people should be reading your research paper to go to your blog, not vice versa, right? Um, write research papers. Essays are little different. In essays are little subjective. You don't have to give your methodology. Essays is something which you think of what you account for. Right, these days essays are not very much published in journals, but they're part of your assessments, because at times you need to take opinions on few matters. And blog is something I think which you should, until and unless you are in PR or you want to start a law octopus or something like that, in that case you should be uh, blogs not for credible law researchers, for sure. Probably once you have gained that stature in that particular law, then you can start.
All right. I think we'll have to stop our question and answer session here, although we have so many more questions. So I would request the participants that they can access, they can reach out to us, and we'll try to give these questions to Shashikant Yadav so that he can reply through email, and we'll get back to you on that. So thanks, Shashikant, for such an informative and enriching session. I thoroughly enjoyed it, and I'm sure that it was very useful for our participants as well. So before we bid adieu to you all, I would like to walk you through our website where you can take various courses given by industry experts and learn from the experience of legal moguls through our talk session as well. So I'll just share my screen with you all. Is my screen visible, Shashi?
Yeah, it's visible.
Yeah, so this is our website where we are offering various courses. These are all given by industry experts and lawyers and academicians, known academicians. And we also have talks under the talk session where we have shared the experiences of Mr. KTS Tulsi, Mr. Ram Jetmalani, Raju Ramachandran, and there are various panel discussions as well. So I hope you all join us through our website, and you can also avail the facility of these courses. Uh, Also, we have a YouTube channel, which is EBC Learning. You can subscribe to it, and you can also click on the bell icon so that you can get all the updates. All our webinars are live on YouTube, and you can see we have the previous recorded webinars here as well. And we also have few subjects which we have uploaded from on our website. So you can go through few of the courses here as well. And be a part of EBC learning. Uh, so I guess that's all for today. For any queries, you can always reach out to us through our social media handle, and we'll get back to you. So any final words, Shashikant?
I think I thoroughly enjoyed, although I could not take all the doubts, but there are very relevant questions on research and methodology, which I could see. And I hope to interact with all of you again sometime to cater those questions. Thank you. Thank you very much, Anusha, Abhinandan, and all of 180, 190 people who were part of this session. Thank you very much.
Thank you so much, Shashi. Have a great day.
Thank you.